Hi everyone, this is Shashank and I'm a law student studying in the glorious capital of India, and in today's video I am going to explain you the Article 14, which is right to equality. So basically I will make this video in two parts. In this first part I will explain you the basics of Article 14, and in the second part I will try to go deep and will explain you the most landmark cases which gave shape to the Article 14. And if you don't know that, I have already made a video on Article 12 and Article 13, and the links of both are given in description as well. You guys can go and check the same. And in this video I'm going to cover Article 14, the basics of Article 14. And if you remember, as I earlier told you, that fundamental rights are available against state, so it is very important that Article 14 should be there. Article 14 says that the state shall not deny to any person equality before law or equal protection of law. It means the state shall not deny any person the equality. However, the terms like equality before law and equal protection of laws, these are quite similar, but still they are different from each other. And let's see how these are different from each other. The Article 14 uses two concepts, equality before law and equal protection of laws. The term equality before law can be found in almost every written constitution in all over the world which guarantees fundamental rights. But however, both these expressions have been used in Universal Declaration of Human Rights. The term equality before law is of English origin, and the second term equal protection of laws is an American concept. The term equality before law is somewhat negative concept. It implies there is no special privilege given to anyone and all are given a same place, a same stage, and law is applicable to all in the same sense. This is equality before law. However, one dominant idea that is common in both the expression, that they both demand equal justice, and the second term was equal protection of laws. It is more of a positive concept. It says we should demand equality, we should do things that creates equality. So first one is a negative concept and second is a positive concept. Rule of law means that no man is above law and everyone is equal in eyes of law. It doesn't matter whether you are prime minister, a constable or a collector. A law will impose same responsibility on all of them equally. According to Professor Dicey, rule of law has three different meanings. So the first is absence of arbitrary power or supremacy of law. It means a man can be punished for breach of law, but nothing else. The second is equality before law. It means that no man is above law with the sole exception of monarch, which can do nothing wrong. And the third is the constitution is the result of ordinary law of land. It means the sources of rights of individuals are not in written constitution, but rules as defined and enforced by courts. Equality before law means that among equals the law should be equal and should be equally administered, that like should be treated alike. And now let's see the difference between equality before law and equal protection of laws. First, let's talk about equality before law. It's a concept implying absence of any special privilege by birth, creed, etc. All the individuals and classes are equal before law. The second term, equal protection of laws. It means equal law should be applied to all in same situation, in same circumstances. Okay, it means all the persons similarly circumstanced shall be treated alike, both in privileges conferred and liabilities imposed by the law. So here I have told you that what is equality before law and equal protection of laws. So here let's see an example. Equality before law says that even a child or an adult should be treated alike. It says that a law which is in any statutory, it says the law should be imposed in the same sense on a 5-year-old child and a 50-year-old man. But in equal protection of laws, it says that all the person in 5-year-old category must be treated alike and the persons who are in 50-year-old category must be treated alike. So here we see a term which is reasonable classification. So here we have categorized the two things separately and we are treating them alike. All the persons who are in 5-year-old category must be treated alike and all the persons who are in 50-year-old category must be treated alike. We cannot impose the same law in both of them because they are both are differently circumstanced and the situation of both of them are different. Okay, we cannot impose the law in the same situation in the same sense on all of them equally. We cannot say 5-year-old and 50-year-old is the same thing. So what equality before do is, so it does not classify things on a reasonable basis. It sees all the persons equally. But on the other hand, we have the equal protection of laws, which is a positive concept. It creates reasonable classification. We do reasonable classification on several bases. So we don't have to put a same law on everyone's face, whether they are similarly circumstanced or not. So in this video, I have told you about the basics of Article 14 and equality before law, equal protection of laws and rule of law. These are all basics. In the next part, I will go deep in each and every part of Article 14, like the exceptions of rule of law, is equality a positive concept, and the most importantly, reasonable classification, whether the classification done under Article 14 reasonable or justified. And also I'm going to pick up some major landmark cases on Article 14 and will try to explain you the major things that has been evolved, that has given shape to Article 14. So that's for it now. Thanks for watching.